So something that pretty commonly comes up in business transactions are something called reps and warranties, representations and warranties. Today, I'm just going to talk a little bit about what exactly they are and go through basically some samples of what they would look like and issues to look out for. So let me just share my screen. So what exactly are reps and warranties? Representations and warranties. These are commonly found in certain types of contracts. Usually it's a type of contract when you're buying or selling something, a purchase contract for real estate, M&A deal where you're buying a business or selling a business. Usually you'll see them in purchase contracts. Typically, the reps and warranties clauses are dealing with matters of fact or possible issues that kind of form a basis or the foundation of the deal. That is a promise that something is either true or not true. Those are the most common types. Why is it important? It usually ends up being a huge section of the actual written contract when you're purchasing something, and it can have huge ramifications. Number one, if something in there, while you're going through that process of drafting them and negotiating them, the deal falls through because something turns out that it wasn't really true. This also kind of corresponds with diligence, due diligence on property or assets or whatever it is that you're buying. Also, lawsuits, it usually forms the basis for a large amount of lawsuits that happen after you close. Let's say you buy something, you close, and a few months down the road, somebody finds out, the buyer finds out that you sold them an asset or a piece of property that you said had no liens on it. So there's no liens or any kind of loan against it where a creditor could later come after that asset. Turns out that wasn't true. There actually is some type of a lien against that property, which obviously affects the transaction and the value of that property. So it usually ends up leading to litigation later. Common area that you'll find these in is M&A and purchase agreements, whether it's an asset purchase, stock purchase, even in merger agreements. Reps and warranties from the buyer, the seller. Sometimes if the company is separate from the seller, the owners may have separate reps and warranties. So let me show you an example from an asset purchase agreement, just a blank form. And so let me switch over so you can take a look at that. So this is just a blank common form of an asset purchase agreement in a typical M&A type of deal where you're buying the assets of a company. And obviously you've got a buyer and a seller. So usually there's a whole section talking about representations and warranties of the seller. They go over things like, does the seller actually have the authority to enter into this transaction? Are they properly formed? If they're a legal entity, if they enter into the transaction and sell you these assets, is this going to cause any kind of breach of other contracts? And it also goes into things that you may have been provided in diligence on the deal, whether it's through a data room or delivered to you by email. You might have gotten financial statements, lists of assets, information about the company and its assets. And so it basically talks about, okay, what we provided you, the financial statements, yes, we represent and warrant to you that these are true and correct. Also that maybe there's been no changes in the condition of the business since those financial statements were prepared. They also may have what are called disclosure schedules, which will be attached to the purchase agreement. And they would be typically at the end of the purchase agreement, and it'll say disclosure schedules, and it'll cross-reference. So in here, it says section 4.06, material contracts. Section 4.06 of the disclosure schedules that would be attached list all of our contracts that we have, material contracts, and it outlines the type of contracts. And it'll usually say also that unless we say something otherwise in the disclosure schedule, we're not in breach of any of these contracts. Also things that are obviously important when you're buying an asset, that the seller actually has valid title. So you represent and warrant that, yes, we actually have valid title to sell this to you. and that the assets are sufficient for what you're buying them for. Because obviously, if you close on the transaction and it turns out they didn't have title, then you want to have a basis for a lawsuit against them later. This also goes over other different types of assets, intellectual property, also making sure that things like, are you currently being sued? Are you subject to some kind of regulatory action that could affect the assets in the future? Like the government, there could be a tax lien potentially against an asset. And is somebody going to come after this asset later after I close this transaction? That you're in compliance with all laws, you have all permits. It can get pretty detailed in terms of things like intellectual property, environmental issues, employee benefits, making sure you're current on any of these. Some of these may not apply as much in an asset purchase because you might not be taking on their employees, but these are just an example of some of the things you might see in the representations and warranties of the seller. Things like, are we current on taxes? Do we have a broker in this transaction that might be getting a commission? So we want to make sure that that's in there so that after the transaction, if there was no broker by the seller, that later somebody doesn't come and say, hey, I was a broker on that. I was entitled to a percentage commission and I never got paid. There are also reps and warranties of the buyer. Usually they're a little bit more limited. They talk about the buyer has the ability to do this transaction, whether they have a broker. It might cover things like, do they have the money to actually pay for this? Are they subject to any lawsuits or litigation? That they've done their due diligence? So those are the types of common reps and warranties in an asset purchase agreement. Again, these can be very short or very long. Typically, in some cases, they take up more than half of the actual contract when they get very detailed about specific types of assets and the business and its financial statements. And these will generally form the basis for potential future litigation. There's also usually closing conditions that in order to close the transaction, all of these reps and warranties that we've listed up here are true and correct at the date of closing. So not only are you representing and warrantying these things in the contract, but in order to close, they still have to be accurate at the time of closing. So that's normally a closing condition that all reps and warranties, it's listed down here. Reps and warranties of the seller are true and correct as of the closing date. Otherwise, we cannot close. And it's usually the same thing for the seller. The reps and warranties of both buyer and seller need to be accurate as of the closing date. So that's just an example of how you would see reps and warranties in a typical like M&A transaction. And it's very important because we get a lot of clients who look at these and it's a huge section they have to go through and disclosure schedules to prepare. And they're like, this has nothing to do with how much I'm paying, what I'm getting. It's not that important. It is. It's hugely important. So you always want to make sure that you've gone through these in detail, and they can be kind of heavy legally with, hard to read sometimes, but you want to make sure because somebody's going to read this and say, hey, that what you said in here is actually not exactly true. And next thing you know, you're getting sued. So always make sure you've gone through these in complete detail in any type of transaction where you have reps and warranties. Thanks for watching, and be sure to follow for additional content.